Florida attorney L. Reed Bloodworth is founder and CEO of Bloodworth Law, an Orlando and Winter Haven law firm founded in 2016. Today, Bloodworth Law PLLC is a U.S. News and World Report best law firm and features a team of skilled attorneys who handle trust litigation and probate or estate litigation for Florida clients. A commonly used trust or estate planning device is a sweetheart will or a sweetheart trust. So, what is a sweetheart will or a sweetheart trust, or a combination of the two? Reed explains that a sweetheart will and sweetheart trust are estate planning devices whereby spouses or couples design their will or trust, or the combination of the two, to leave the other everything upon one of their deaths. So, for example, if the husband passes away first, his will and/or trust would leave everything to his wife. The second part of that is a typical sweetheart will or sweetheart trust. In addition to leaving everything to each other, upon the death of one in the couple, upon the death of the second spouse, everything is typically then divided amongst the children. So the husband's will or trust would say essentially, upon my death, I leave all of my possessions to my wife. First it would say, if I predecease my wife, then all of my possessions are hereby bequeathed and left to my wife. And then it would say, however, if my wife predeceases me, upon my death, all of my possessions are left to my children in this fashion. And that could be in equal shares or different percentages. But that is the typical makeup of a sweetheart will or sweetheart trust. They're common, and there are not many problems with that style of estate planning. Where the problems arise is when the children are under the impression that these estate plans are going to remain in place after one of the parents die. Let's say after dad dies, everything goes to mom. Well, then mom goes and gets a new estate plan and maybe doesn't tell the children. And then you have the issue of, well, she changed it and she wrote one of the children out. So there are a lot of situations after the first spouse passes away where issues can arise. That's a big one, the biological children versus the stepchildren. That's probably the biggest issue when one of the parents passes away. You had a sweetheart will or trust. That parent got everything from that marriage, and then that parent remarries, and then new estate planning is done. And sometimes that's the situation where you see perhaps that parent starts to lose their mental capacity, and all of a sudden, new estate planning is prepared where the biological children don't get anything, and the stepmom, and often the stepmom's kids, get it all. That can be problematic. So it's not necessarily the first step in the sweetheart will or trust that's problematic. That's common. There's nothing particularly wrong with that. It's after the first spouse dies, the second spouse then has the ability to do whatever they want with their estate planning, and that's when things can change. And disagreements can come up amongst children or whomever believed they were receiving an inheritance from those parents. And they don't know until after someone has passed. But that depends on whether they're asking, or unless the parents tell them, or the surviving parent tells them. That's something I often advise my clients of, is to be open about your estate planning with your family, so that there really aren't surprises, Reed said. If you have a legal dispute that needs to be addressed, talk to Reed and the team to find out how Bloodworth Law can help you, your family, or your business.